then this is a really good place to start. The value of knowing acronyms cannot be overestimated because, first of all, if you're in a conversation with somebody and they're throwing around a lot of acronyms and you indicate repeatedly you don't understand what the acronyms are, you have now put yourself in a lower position of power. And you do not want to do that. What you want to do is have a notepad with you and write down every acronym that comes spewing out of the mouths of this person on the other side, and then use the materials that you already have been provided that is a list of acronyms to try and figure out what the hell they just said. So we're going to go to the next slide, which is how many of you think you know all of these acronyms? You actually, we're going to ask for a volunteer. Do any of you think you know all the acronyms? Jerry, you know all these acronyms. You want to chop with me? How many of you think you know like 5 of the acronyms? Okay, who wants to give it a try? Go up here, sir.
Okay. The Agency for Healthcare Administration, Department of Children and Families, Children's Medical Services, Department of Health, Department of Administrative Hearings, Office of Administrative Hearings, Health and Human Services, and Department of Justice.
Oh, okay. You get not only a chocolate, but you get the grand prize of an alligator pen. Oh, well, that's okay because that's a donut. Yeah, that would have been good. And actually, I bet most people would have gotten it wrong if they thought they knew it because it's Centers for Medicare and Medicaid Services. So it's missing an M. And actually, it's also consumable medical supplies. So that would have gotten a car and a trip to Hawaii. Okay, I thought it made more sense when Medicaid to me, and I think everyone agrees, is kind of a labyrinth, but it makes more sense always to me if you can attach the problem to a scenario. So I've devised a scenario, and unfortunately I didn't get it in your materials, but it's not too complicated. So you've got Ms. Bell, who's a single parent. She works as a caregiver for an elderly couple, but she is not insured. She has 3 children. April is 4 years old. She's a paraplegic and has a seizure disorder. Mark is 12 years old and has been diagnosed with autism and intellectual disabilities, and he has some severe behavioral problems. He's nonverbal. June is 15 years old, and she's typically developing. So Ms. Bell has been taking April to work with her with the consent of the elderly couple she works for, but she injured her back trying to transfer April from a wheelchair into a bathtub, and to give her back rest, she left April with her oldest daughter one afternoon. June has also been watching Mark after school, and on this particular day, Mark tried to elope. June tried to block him. He pushed her aside. She broke her arm. She called 911. They come out, and ultimately what ends up happening is that April ends up in a nursing home. Mark ends up in a family foster care for persons with intellectual disabilities, and June is placed with her grandmother. So no exclusions to DCF. This is kind of like the worst scenario. Hopefully it doesn't happen. But now you're appointed guardian ad litem, and what's your task? So your task is twofold, really. It's to try to make sure these kids are getting appropriate care in their placement, in their current placement, and then it's to try to figure out how to get them appropriate care so they can be reunified with their mom. In order to do that, you're going to need to figure out how Medicaid works, and what does Medicaid offer, and what's EPSTD, which is going to be a focal point of my talk. And for reunification, you're going to need to try to figure out how to keep Medicaid or find some other option, and you're going to look at the Medicaid waiver programs. So to me, which is how it's supposed to work, and Marion, which is how it actually is working. And she understands it from all angles, medical foster care as well as an adopted parent of special needs kids. And then Kirsten is, if it's not working, how do you get it to work? So Medicaid is a federal-state joint program. Sometimes the state seems to forget the federal part of it. I want to get the federal back in again because they do in fact run the majority of the program. And the state is actually the administrator of this program under federal regulations and laws. And the state has to submit what's called a state plan to CMS, the Centers for Medicare and Medicaid Services, and get that plan approved so that they can administer the program. It's like a contract between the government, the two governments. AHCA, the Agency for Healthcare Administration, is the supposed single state agency over all of Medicaid. That's a federal requirement. You have to name one agency has ultimate responsibility. There's financial eligibility for all categories of Medicaid, and there are a lot of categories. Children is one separate category. Anybody on SSI, Supplemental Security Income, that's a separate category. In your handouts, I put together a kind of a cheat sheet for Medicaid and Medicaid-related programs and waivers and the CHIP programs, Children Health Insurance programs. And I don't know if it's exhaustive, but it was exhausting. And it's seriously, don't lose this sucker because it took me forever to do. Because all these different programs have different categories of eligibility and different ages and different financial requirements. It's really kind of a nightmare. But now you have something to consider. You have this little pamphlet. Not little, it's like 10 pages. So in addition to the eligibility criteria, you're going to need to learn medical necessity because any service that's offered has to be medically necessary, and there's a statute, there's a rule definition for that. It's 5 different prongs. I can't tell you all of them. I have to look at it every time because it sometimes doesn't make a lot of sense to me. These are a list of the state plan Medicaid services. There are certain services that are mandatory that every state must offer, and then the state gets to choose in their state plan which other services they will offer. You'll see that this weird little EPSDT for under 21 is highlighted, and that is because for children, it's really the key service. It's how they get everything else pretty much. And they can get not only the mandatory services, they can get any of the optional services, they can get services that are not even provided in the state of Florida to adults. It's a extremely important concept. And I'm going to, going backwards a little bit, explain that state planned Medicaid, and that's often how you will hear it. Has anybody heard that phrase, state planned Medicaid? That's the type of Medicaid that is offered to the typical hospitalization outpatient physician insurance. It's not a waiver program. It's what's available. It's an entitlement. It's what's available if you qualify under the financial and categorical criteria. So as I said before, children, that's its own category. So yay, for children under the age of 21, if you meet the financial criteria, you should be able to get Medicaid, even if your parents can't. When a child goes into state custody, they automatically then get Medicaid. That's why I'm kind of focusing on this part for April and March and June right now. They're on Medicaid. So let's see what we might be able to get them when when they have Medicaid services. So, you guys need to write this down, memorize it, and I will tell you how to memorize it, because that's too many acronyms. You need to remember President Nixon. Every president should destroy tapes. So now you will not forget it, right? Right? Okay, what it really means is early and periodic screening, diagnosis, and treatment. That's what it means. And that comes with, and oddly, I never hear anyone talk about it this way, but if you look in the Florida Medicaid Summary of Services Provider Handbook, which is online, and you have links to all of this, they call it child health checkup. So it makes it sound like it's just bring your kid in and we'll check off a list. But in actuality, it's from like start to finish. It's like the obligation to figure out what is going on with the child. Actually, even before that, it's the obligation to let everyone know that this is out there for children on Medicaid, and then figure out what's up with that child, diagnose it, and then figure out what is needed to treat it. So the diagnosis, and this, I'm only reading, I don't hate it when you get all this stuff on screens, but this is really important because it's actually something you can sue under as an individual civil right under federal law. EPSTD includes diagnosis and treatment, necessary healthcare diagnostic services, treatment, and other measure described in the Medicaid Act to correct or ameliorate the physical and mental illnesses and conditions, whether or not such services are covered for adults in the state's Medicaid program. So that means that it's a much broader definition. There's some debate about whether the medical necessity for that is different. I think that there is some argument that in fact the medical necessity standard is a little lower, but for sure everyone's in agreement that there's a much wider selection of services available.
Can I ask if this is going to still be in place with the new managed care system?
Yes, the managed care systems must follow federal law. Write that down, tattoo it somewhere. And ACA is ultimately responsible that that happens. So if you're going to sue for a violation, you should add ACA in. Just all you ACA people out there, just so you're not feeling left out. Here's the kicker for EPSTD. It actually allows children to get home health services. If you know anything about Medicaid for adults, the state plan Medicaid for adults, you can't get those. You can get skilled nursing at little short intervals if you need something like wound care or like rehab after hospitalization. But you can't get private duty nursing. You can't get a personal care assistant or CNA to come in and help on a regular full-time basis. But you can for children. And so for children, even children who end up on one of the Medicaid waiver programs, and they automatically get Medicaid, most of their services will be provided through state plan Medicaid. So you're going to be dealing with either ACA and EQ Health Solutions, which is the organization that has been contracted with ACA to provide prior service authorization for home health services. Or you're going to be dealing with a managed care situation, which is a whole other workshop. And I've actually done another workshop on managed care and how you deal with that. The one thing about managed care is that there's a two-step appeal process, or two choices that you have, not exclusive choices. You can do an internal appeal through the organization, Or you can do a fair hearing. We're going to be talking about the fair hearing end of it. Like I said, that the dealing with internal appeals is a different topic. So, in addition to home health care, there have been court cases that have been filed under Federal Civil Rights Act, specifically under EPSTD, that said incontinence supplies are required to be provided. That was a Florida case. There's a Massachusetts case, the big case that was said that the state had to provide service coordination, crisis services, and in-home supports for children with serious emotional disturbances, so wraparound services. And most recently, in the Southern District, and was approved by the 11th Circuit, applied behavior analysis services for children on the autism spectrum disorder with ASD. Not just children with autistic disorders, what they used to call it in DSM-IV. So for the Bell children, we have April, who's in a nursing home, and that's the least nice option, the most restrictive option for her to be in. So as a guardian ad litem, you're going to want to look at other options. Medical foster care is this weird creature that is actually a service offered through state plan Medicaid, but it also has elements of control by CMS and the Department of Health, or some other NDCF. So looking at medical foster care, that is in fact a service, and that should be covered under Medicaid. Also, if you've got April has potentially some complex medical conditions, including the seizure disorder, and you might want to look at children's medical services and see if she can be given a case manager and services under children's medical services. Is there anything else that you can think of that might be helpful to this little girl? For Mark, I've got to say that the most difficult cases are cases involving children that have serious behavioral issues, and children with autism, children with co-occurring mental illnesses. We don't know a lot about Mark. And, I don't know how much we know about April. She may need an assessment. There's a lot of things that could be happening with April we don't have enough information on. Mark, he's now, where did I say he was placed? Oh, he's in a foster care facility. Is he knitting? He's 12. It's best to get ABA services when they're really young. But they're offered now up to the age of 21. And I've seen it impact kids that are, and adults even, who haven't had it. I have had a client who was in his 50s when he learned to speak with behavioral services. So you're going to need to look into getting ABA services for him in place. He may need other kinds of supports as well. He may need a more thorough evaluation. All those things are things that you need to explore in terms of what they're getting in their placement.
What are the evaluation in order for processes for getting?
You can, in order to get Medicaid services, you're probably going to need to, I typically work with providers who are doing the requests, but you're going to need to work, we're going to go talk about getting placement in a waiver. At this point, almost, like I said, almost every service they're going to get, they get through state plan Medicaid, even home health services. And you don't need to look so much at the respite part of it, which state plan Medicaid does not offer, because it's the state. What's the state going to say? I'm tired? Well, yeah, so that's not so much an issue right now with these kids. Yes?
Nancy, I know this is in a lower range, but what are ABA services?
Applied behavior analysis services, and those are the ones that just got out of a court case saying that the state plan Medicaid has to offer them to children. For June, I think it's like, it's no brainer, she's gonna need some counseling. And that is a covered service, she now has Medicaid, that should be something to consider. So, then, once you get that figured out, what's going on with these kids in state custody, then the next step, I think, would be, how do we get them home? You know, at least under what you know of my scenario, the mom's doing what she can. There's nothing wrong here except that there's not enough of her. So you're going to have to look at how Medicaid eligibility is going to transition when they go home. The next thing you're going to have to look at is Medicaid waiver programs and possibly other options besides Medicaid. So Medicaid eligibility, as I said before, is based on categories, and children, you're golden with that, so you know that's going to work for them. But the financial categories are really complicated and they change. For children, they're now using MAGI, modified adjusted gross income. It's on your tax form somewhere. And they look at the household income. So it's going to be what the mom is making. And if she makes under 138% of federal poverty level, then then the family will qualify for Medicaid. Well, you got to assume that probably she's not. She's making more than that because they weren't getting Medicaid before. For SSI, the children, two of the children at least, might qualify for SSI, but SSI is an income and asset test, and it's lower actually than the 138% of federal poverty level. Now, here's where the waiver comes into play, because if you are enrolled, not on a waiting list, but enrolled in any of the waiver programs, the enrollee, the individual child, is considered to be a household of one. It is an income and asset test, but it's the institutional care placement test. So the income, and it's also the income of the child, because kids aren't making anything. But if they were, they'd be able to make 3 times whatever SSI pays. That's the income for a month. And the asset is $2,000. So that's why you see people have a lot of special needs trust for these kids. So they don't ever get over that asset limit. So how do we figure this out? So let's say they don't qualify for Medicaid. There's an option called medically needy Medicaid or share of costs. Has anybody heard this before? Has anybody actually successfully used it with any of their clients? It's a rare critter. It's very complicated. I recently went through the regulations that relate to rules that relate to medically needy Medicaid. Some of the handbook information. There's no separate handbook. And it seriously makes no sense. If you were to try and diagram some of these sentences, you'd blunt basic English grammar.
Nobody understands it.
No one understands it. You get 2 or 3 opinions, sometimes from the same people. But essentially, what it is they look at your total. They're supposed to use, once again, now they're supposed to use the modified adjusted gross income. I don't think they're doing that, so that's one thing. The second thing is that they often, the share of cost is pretty much, you can say it's like close to their actual monthly income. And there's very little in modified adjusted gross income that is taken off of income. I think some level of alimony would. But they take like a household amount that's about $200 per person in the household, and then they come up with your share of costs. So I just try to tell people it's pretty close to your monthly income. If you have Medicaid reimbursable expenses that exceed the share of cost, then you're covered for Medicaid on the day that that happens in the month, for the rest of the month, and it's a month-to-month thing. Now, I personally know of people who are able to use this successfully, but what it requires is that the Medicaid reimburse. First, it requires you have a Medicaid provider that will take medically needy, and not everyone does. So that cuts you down. I've heard, I'm not sure this is true, but I've heard someone say in another workshop that only 4% of the physicians in the state of Florida take Medicaid. Some extremely small number, don't quote me on it. But now if you drop it down even further, finding people who will want to deal with medical need is pretty tough. But it can be done. And if you can work it so that the bills come in at the first of the month at the same time, then that person will be covered for the whole month, and you don't have to actually fork over the share of cost. But it doesn't work very well if you've got services, if you're trying to bill for services, because you apparently have to, you only incur that amount on the day the service is provided. It works great for pharmaceuticals. If you, I had a case with a kid who had one psychotropic medication for a month that hit the share of cost. So that family, it's like being on regular Medicaid. You're not having to pay anything. I don't recommend it though. It's a very difficult program if you can find, if you have any other options. So some of the other options are does anyone know what CHIP stands for? Chocolate? It's what? Yes. Yes, you win. So it's Children's Health Insurance Program. Actually, that's a double program there. But that's a Title 19 of the, I get 19 and 21 and stuff. 21 is Medicaid, 19 is CHIP. And it's an extended program for children. It can be done one of two ways. It can be done by just giving subsidized insurance, or it can be done by essentially just extending Medicaid. Florida does it both ways. For children under the age of 5, it's extended Medicaid, and you can get on it. You have to pay it like $10 to $20 a month premium. But the household income is up to 200% of federal poverty. It is the Medicaid package. EPSTD does apply. So April could get home health care under that version of our CHIP program, which is called Medikids. When she hits 5, unfortunately, she goes into what's the insurance component of our CHIP, which is called Healthy Kids, and that's up to age 18. It doesn't go up to 21 like Medicaid does. And that's under an insurance policy, and I swear I cannot tell if you can get private duty nursing through looking at the benefits, looking at the statute that describes the minimum benefits for healthy kids. It's very convoluted as to whether you could get private duty nursing. If you are, however, she may qualify for CMS when she turns 5, and then she would get private duty nursing. And that is also part of the CHIP program. CMS goes all the way from Medicaid through the subsidized CHIP program up to 200% of the federal poverty level. June is going to qualify for healthy kids. So at least she'll get some regular, and it's good insurance. It's not everybody takes it, but I think it's probably more people who take Medicaid. There's another option, and that's CHIP full pay, and that's paying a premium to get those kids on that program. And it's definitely worthwhile for families that would otherwise have to use that silly medically needy share of cost. And it's definitely worthwhile for people that have young kids up to the age of 5. I mean, if you're paying $500 a day for a private duty nurse, wouldn't it be better to pay $200 a month for full pay Medicaid? Now, it's not an entitlement. They can cut it off. And if a lot of people do what I just said, they probably will, because it's not funded. It is a partly federally funded program. And it actually has a higher rate of match by the federal government than the state does, than Medicaid does. The Affordable Care Act, that's another option, not going into it, kind of complicated, but easy to access now. So, and then we go into the Medicaid waiver programs.
If you go to the Medicaid program, don't go to HE, the foster care center to age 21, whatever it's going to be.
CHIP only goes to age 18.
Okay.
Medicaid goes to age 21.
Oh,
Oh, that's right. Medicaid has actually been extended to age 26 for children in foster care, and that's that were in foster care and getting Medicaid when they got out of foster care. And there's a handout. There's a handout in there on that too. I mean, it's not. There's certain parameters to it. You can't. It's just not every kid that was in foster care. You have to reapply? Okay. Trying to get my timer back up here. Sorry, guys. So, does anybody want to try this one? It has to be somebody different. So, you guys should know the first one. These are the programs. These relate to the information you need to know about the programs. So we have every president should destroy tapes. Okay, go, you go.
DPSVT is early periodic screening, diagnosis, and treatment. ED is developmental disability. iBudget is the managed care iBudget system. Is that right?
No, but I'll still give you chocolates.
Okay. TBI is traumatic brain injury. I'm thinking LTC is long-term care. And ACA is the agency for, Affordable care.
Affordable care, that's right, all right. Sorry. You don't get a candy, you get 2 chocolates. So, iBudget is the new system for funding the developmental disabilities waiver under the Agency for Persons with Disabilities. And LTC, long-term care, did you get that one? Yes, yeah. That's actually the program that now combines a bunch of waivers, mostly for elderly people, but not all, into the managed care program. So my timing system is totally gone. 11:09. Okay, I need to wrap it up, guys. So the Medicaid waiver programs, what are they waiving? You know what? They're waiving certain requirements under the Medicaid Act for instance, providing services to everyone throughout the state as long as they're eligible. So statewidedness is the term for that. And they're usually waiving some level of amount, duration, and scope because their services are sort of they have a list of services that are more limited. And then they usually have a target audience, and you have to meet certain eligibility criteria. They all have to meet, and this is a federal requirement, they all have to meet the level of care for institutionalization, and it kind of depends on the institution. For persons with developmental disabilities, it's called an ICFDD, an institutional care facility. for developmentally disabled. There is, like I said, there's a financial eligibility criteria, but it's based on that single person, not on the household. And that's where, for these 3 kids, it would make a huge difference if they were enrolled in the waiver. The developmental, the DD waiver, the I-budget waiver, has 6 different criteria for eligibility and or types of diagnoses. The first one is it's autism, but it really is what used to be called autistic disorder in DSM-4 and other variations on that theme. It's statutorily defined, and it lists exactly what you have to have this many out of this many symptoms out of this section, and this many out of this other section. That's been a real problem because doctors don't diagnose based on outdated DSMs. And autism is really hard to correctly diagnose. I can't tell you the number of kids that I've had that have gotten good intervention, and now they know they've had a delay in speech, and now they can speak, and so people now start diagnosing them with Asperger's syndrome. But they don't have Asperger's syndrome. That's one of the main features, is that there isn't a speech component to that. They have autism. So that's an issue, but in addition, there are also cerebral palsy, intellectual disability, and that's got a cap on a level of IQ or at least subparts. Down syndrome was just recently added, spina bifida, Prader-Willi syndrome. Now you can have any of these diagnoses, no questions asked, and still not be eligible if functionally you don't need the ICFD level of care. I mean, somebody with cerebral palsy could just have a problem that causes a limp. So you're not going to get eligibility based on that. And also, please note that it's not all people with intellectual disabilities. There are a lot, I think the majority are people with intellectual disabilities. I have clients that type me emails with their foot. They're the people with spina bifida, Prader-Willi syndrome can be very high functioning and have no intellectual disability at all. It's administered through the Agency for Persons with Disabilities. There is, as you know, a long waiting list. How do you get off the waiting list? There's a rule that actually sets up the crisis criteria for getting off the waiting list, and it has very significant factors that are indicators that you need to be, if you're going to try to push for somebody for crisis enrollment, you need to look at. The first priority is homeless or essentially about to be homeless. The second priority is not just danger to self or others, but a serious danger to self or others. And some people have told me the only way that they think people can get on is being consistently Baker acted or putting somebody in the hospital. And that isn't true. You can get people on by showing that is a likely occurrence if you don't get services. The third priority is the caregiver is under duress or unable to give care. And that's a big factor. I mean, there are people who have been completely burned out. I've had cases where I've had to show photographs of the parents with big bruises and bite marks, and they can't manage. They can no longer manage. Their household's falling apart, and maybe they can't manage because of mental health issues. They're having breakdowns. It's sad to have to get the information to prove that, but it can make the difference between that family just going to hell in a handbasket and getting enough services to be able to live through this. Yes?
I've heard that also, in order to advocate for your client getting off the waiting list, is to request a placement in an ICU?
You can do that, and here's why. A placement in an ICU, if somebody meets the eligibility criteria, they are now determined to have have been eligible for placement in an ICFP. That's an entitlement. That's a state plan Medicaid option. Unfortunately, I have a hard time getting parents to say that they would ever do that. They say they'll die first, and sometimes that happens. I had a client call me on the phone who was having cardiac arrest. And she couldn't breathe, and saying, I'm not going to go to the hospital until somebody's here to take care of my grandson. I think we dealt with that together. Thank you. So I've kind of gone over that, and this is a list of the options that you need to think about. For April especially, you need to dig deeper. Why is she paraplegic? Is it because she has cerebral palsy? Bingo. She qualifies. One more question, and then I'll do that.
It's more of a statement. They also gave a priority last year in the legislature when we allotted that $31 million to ADP. Any children that were in foster care that were being reunified or adopted would be put onto a waiver upon adoption or reunification. I know 2 months ago we successfully did that in Broward when we with a reunified family. They were supposed to be redoing that in the legislature. I don't know if that happened or not this last session.
Thank you. I think that's really important to point out. That's not something that I knew a lot about because I don't deal with foster kids that much. But that, in that base, I guess that's based on the cycle of appropriations.
I mean, it wasn't limited to statute last year. Like I said, I'm not sure if it was renewed for this year. I know they were trying to.
Okay. And somebody needs to really check up on that and see if it was, because that's a very important piece of this puzzle. Marion is an amazing person. She worked as a medical foster care home for 6 years until 2011, and had numerous kids with all sort of very complicated issues go in and out of her home. She adopted 5 and has 2 of her own kids. And so she has seen the system both from the inside as a provider, so to speak, and the outside as a mom of adopted special needs kids. And 2 of her kids at least require significant nursing care in the home. And we'll go back and forth. I'll ask her some questions, but I'm going to let her talk about her experience and, some of it. I think she'd say she do medical foster care again. She just loves these kids. Are there problems? Yes, there are. And then some of the obstacles she's had, she's still dealing with.
Thank you, Nancy. I don't know where to start, but I did medical foster care and I loved it, and I constantly want to recruit people to do it because unless you do it, you don't realize how rewarding it is. The kids, we all have a place in this puzzle, we're all different, we have all different roles for these children, but we're all wanting the best for them. And being in medical foster care is such an integral part for these guys to be loved and get taken care of what they need and hopefully be unified or be adopted. But anyhow, so my children, they are ranged from 7 years old until 22. My 2 that are very involved are 8 years old. And then my oldest son is 22 and he's on the wait list of the Medway. And we're hoping to get his approved so he can be in a residential facility with a life coach. My son actually benefited, my 8-year-old benefited of that $31 million that was allocated for the adopted kids. So Jacob is already on the Medway because when I adopted him, he was made available for him. So I'm really thankful for that.
Can you tell a little bit about, just as a medical foster parent, what they pay and what sort of training you were able to get?
Generally, you have to be a regular foster parent or a traditional foster parent. You go for like a week of training but really mostly it's you learn the paperwork. You really don't get much training on care. You get in care. I mean, you learn how to take care of children as for each individual child. From if they come to you from the hospital trains you. Usually that's what happens. All the nurses come out from CMS and help you, get familiar with all the needs and all that. The pay, you get the board rate, which is $504, and then you get paid by Medicaid. If you have a very involved child, you get $67 and some cents for 24 period to take care of a child, which ends up, I think, between the board rate and what Medicaid pays you, it's $2,500 a month. Possibly having a child that has a trait, a child that could be terminally ill, a child that's going to need you to be there 24/7. You cannot do it for money. You're going to have to love these kids and just want to make a difference for them. Then there's two other levels where the children are not as involved as a level 2 and a level 1, which, then the pay drops. But he's not great.
So let me ask you a little bit about your kids that you've adopted, and you said you get nursing services in the night, right? How has that been consistently provided?
EQ or Medicaid approved for my children. Well, one child, he could have seizures mainly, and it could happen overnight. So we have somebody, has to watch her. Jacob has a heart condition, and at times his oxygen level drops. So we have to, somebody has to watch him. So Medicaid approved 12 hours every night, 7 days a week, which is wonderful. I mean, I think a lot of people don't get that approved, but it is very hard to find quality home health care nursing. I may have coverage for 3 to 4 nights. So the other nights when I don't have coverage, I have a bed in there and I just sleep in there with them and just pray that nothing happens while I'm sleeping. But it is because if you have the low quality nursing and home health care because the pay is so low. The nurses make maybe half what they would make in a hospital. So most of the time you only get LPNs, and even with the staff I've received in the past, I don't let many people go because you just have to stay away.
Mary's not describing something that is unusual to her. This is a statewide problem. So even if you can get the services authorized, that's not your last step. Getting them actually provided is a statewide problem, I think. And you said you do get on the Medicaid waiver, you get respite services for, is it Katie? Jacob. So do you get nursing respite services?
No, there is no, for the med waiver, there is more of a companion that, was approved for Jacob, and which is, again, it's nice that it was approved, but I really couldn't leave the companion or caregiver alone with him because if there was an emergency, they would be qualified to take care of.
That is not respite. If she were to collapse, you've got somebody now in her place that cannot provide for the safety of the child. And I think that's a statewide problem. It's not a statewide problem. I think that's a regional problem with APD and that we're trying to address. But be aware of it because respite means being able to take care of that child safely if the caregiver cannot. So you want to finalize your
Again, I think it's a great thing about getting the kids moved out on the med waiver. If there's a placement, potential placement to be adopted because it really helped us. I really feel it's difficult, like my son, my 22-year-old now, he didn't even get on the wait list because he kept getting denied and he has autism. So, but at age 18, he finally was able to be put on a midway for waitlist. But we're waiting, and now he's graduating, and he really would like to transition on, but because he's not on a midwaiver, it's not a possibility yet. So it brings a lot of anxiety for him. But I thank y'all for having the interest in, we'll all work together and hopefully we'll make this better for the kids, to come through our system. And yes, I would like to get relicensed. We're moving to Jacksonville, my house is getting smaller. I'm going to do it again because we have to, we can't just be selfish and we have to look out for this.
Marion's not describing something that is unusual to her. This is a statewide problem. So even if you can get the services authorized, that's not your last step. Getting them actually provided is a statewide problem, I think. And you said you do get on the Medicaid waiver, you get respite services for, is it Katie? Jacob. So do you get nursing respite services?
No, there is no, for the med waiver, there is more companion that, was approved for Jacob, and which is, again, it's nice that it was approved, but I really couldn't leave the companion or caregiver alone with them because if there was an emergency, they would be qualified to take care.
That is not respite. If she were to collapse, you've got somebody now in her place that cannot provide for the safety of the child. And I think that's a statewide problem. It's not a statewide problem. I think that's a regional problem with APD and that we're trying to address. But be aware of it because respite means being able to take care of that child safely if the caregiver cannot. So you want to finalize your
Again, I think it's a great thing about getting the kids moved out on a med waiver. If there's a placement, potential placement to be adopted, this would really help us. I really feel it's difficult, like my son, my 22-year-old now, he didn't even get on the wait list because he kept getting denied and he has autism. But at age 18, he finally was able to be put on a med waiver wait list. But we're waiting, and now he's graduating, and he really would like to transition on, but because he's not on the med waiver, it's not a possibility yet. So it brings a lot of anxiety for him. But I thank y'all for having the interest in, we'll all work together, and hopefully we'll make this better for the kids, to come through our system. And yes, I would like to get relicensed. We're moving to Jacksonville, my household's getting smaller. I'm going to do it again because we have to, we can't just be selfish and we have to look out for this.
Okay, we have 15 minutes. That's okay. And I'm going to tell you everything you need to know about fair hearings and that. In the PowerPoint which was provided to you all, I went through some of the kind of procedural stuff about what to expect in a fair hearing. But today together, I wanted to talk a little bit more concretely about what it is you actually would need to prove at one of these hearings. Kind of when you have a situation where you're not getting what it is that the child needs, and you're in a situation where you've gone to the agency and have kind of exhausted all of the options in terms of advocating, and are in a situation where you actually have to go to a hearing. So one of the materials that we had in your handouts was a case study that
Nancy also put together to help us out a little bit today in talking about this. And one of the things that I want to discuss is the first thing is your fair hearing actually fair? So, at a minimum, it has to comply with the Constitution. We have this thing called the 14th Amendment. It requires that before the state takes away property of yours, that it has to give you notice and an opportunity to be heard at a meaningful time and a meaningful manner. And what that means for Medicaid is that our clients have a constitutionally protected liberty interest or property interest in continuing to receive those benefits. There's Supreme Court case law that establishes that, Goldberg versus Kelly, if anyone's ever looked at that case. Basically, when they talk about an opportunity to be heard at a meaningful time, that means that if the agency said, or one of the agencies told you, we're cutting benefits, so you're no longer going to receive the same amount that you did before, that doesn't just get cut off as of the date of the notice, or in some circumstances, 3 months before the date of the notice, or without any notice. Not only are you required to have a notice, but those benefits are required to continue while you're challenging the termination or the reduction of benefits. So that would be a meaningful time that you're getting out of due process rights. So this is the case I was talking about, Goldberg versus Kelly. So these are all the requirements that fair hearing must have. And there's actually a federal regulation that adopts the standards in Goldberg versus Kelly for fair hearings under Medicaid. This may seem, sitting in this room, like, oh, that's such a nice, liberal, academic, thing that's not really that important and doesn't apply in the real world. But my law firm, I think we should rename ourselves the Due Process Law Firm, because all we seem to do is sue governmental entities about due process. It's astounding to me, particularly in the Medicaid context, because there is case law from the 70s. On forward, there's hundreds of cases about just the right to adequate notice. In fact, Nancy and I were co-counsel in a class action lawsuit against APD just last year about giving notice to clients. And Nancy had a very wise thing that she said to me about preparing for fair hearings. She said, as long as I can figure out what the agency's rationale is, like what the reasons they have decided to make a particular adverse decision against my client, then I can usually get it resolved even without going to a hearing. And you shouldn't have to be wondering what it is that the agency has done to whatever agency it is to make a decision. And it must be adequate. It must be reasonably calculated to inform you of your right to a hearing. And I'm going to talk about notice a little bit more. But you also have to have an evidentiary hearing. You have to right to confront cross-examine witnesses. All these things that are important to your fair hearing. Which, by the way, we've had other lawsuits about the right to a hearing. So this stuff is not just academic. So adequate notice, this is all a bunch of constitutional stuff. But basically what it means is, if the state was going to charge you with a crime, they couldn't just say, hey, you might go to prison for 30 years, here's the date of your hearing, have a nice day. We're not going to tell you what it is we're charging you with, we're not going to tell you what the evidence is against you. You're just going to have to show up and figure out how to defend yourself at a hearing. This happens so much in Medicaid specifically, I cannot even tell you. And so that would always be my first question if I had a client who was getting some sort of a reduction in services or termination of services, would be, that happens quite with regularity. And the second is the notice adequate? And what is adequate notice besides these constitutional standards? Actually the federal regulations have very specific requirements for what notice is required. So a lot of times if you do get notice, all you get is the top thing. Like, we're going to reduce your budget for services by $15,000. You know, you can request a hearing. Well, I don't know whether to request a hearing. I don't know if you made, if your decision was based on erroneous facts. I don't know if you misapplied a lot of the facts. If I don't know what the reasons are, if I don't know what rules or law, apply, and so that's why notice is just essential. So let's assume you got some notice, and we're actually going to go to a fair hearing. This is just more about the fair hearing requirement. I have this stuff in from the CFR about services being continued pending the hearing. If you don't get adequate notice and the benefits get cut off, that absolutely must be restored because they didn't do it properly. This is kind of how I look at it. Like, the government must go through these steps to take away a protected property right or protected liberty interest that you have. And if they don't, they're stealing from you. And they must give it back until they do it properly. Aside from all of that, I just want to talk briefly about, how to put together one of these cases. And one of the most important things is to look at the agency's rationale for assuming you get notice, for the decision that they've made. And one of the things that, whenever you're putting together any kind of legal case, you think about what you need to prove. And I don't really have as much time to get into the weeds really on this case study that we have, but basically what I will tell you is that in the case study that we have, the clinical rationale is based on erroneous facts. So that's a really easy thing, and a lot of times that's something you can just go to the lawyer who's on the other side and say, hey, this is incorrect as a matter of fact. Like, look at your own paper file, and this is wrong. And you can work with them and potentially get that resolved. But assuming you have to actually go prove that, you're going to want to figure out, okay, so like for example, in this case that we have, they had the wrong work schedule for the mom. Mom actually works a lot more than the agency thought, so it's really relevant what the caregiver can do in these clinical rationales. And so if the agency is assuming the mom's going to provide care during hours when she's unavailable to do so, well then that's really relevant to the level of services that the child needs. The other situation that's important is if there's been no change in the child's medical condition, but at one time they were approved for more services and then all of a sudden this year they're not and there's no medical change. That's something that's really important and significant. Like, why does the agency think that all of a sudden this year she needs 8 hours less of private duty nursing a day, let's say, than last year? The other thing that's important are other demands on the caregiver. There's other children in the home, physical limitations that the parents might have. Other errors that were in this case study are about the fact that they assume the child was on a normal oral diet and she's not on a normal oral diet. She actually has a lot more feeding through the G-tube, which requires additional care. And this whole case is about access to private duty nursing and ACA. And they're going to have an EQ health assessor who has probably just done a paper review of whatever documents were sent over in a file. And so they're going to get up and testify to things in their clinical rationale that, this child doesn't need the level of care that nursing, the level of nursing that they requested, the mom can take care of her, because she doesn't work, and testify to all these things about her medical care. cross-examining a witness, there's a couple of things. You're not going to win your case just by cross-examination. So you don't have to get this witness to admit all of these things that you want them to admit, because you have different positions and they're going to be on different sides. And I think that's where people really lose cases. They're trying to get someone to admit something that they're never going to admit to. Isn't it true you have no idea what you're doing? Like, no, nobody's going to say that. But you can say to them, isn't it true you have no experience with kids with autism? Isn't it true that, you've never had training about the kind of care that kids with autism require? If you're looking at your CV and you're a podiatrist and they're sitting there testifying about this child with autism, you might have an issue there. So there's things to discredit the witness. I think the fact that they do paper reviews and don't actually look at medical records, never examine the child, never speak to the treating physician, or only talk to them very briefly. All of those kind of things are deviating from standards of care and assessing the child. So those are the types of things. The other thing you can do is detract from your case. The fact that nothing's changed in the child situation from last year to this year. So, but all of a sudden, the level of care that they need, that seems to have changed. Or the fact that the work schedules have changed. Any kind of factual errors that you can, point out. And then you can also use cross-examination to enhance your case. So, either pointing out that the expert doesn't know something, or pointing out that the expert's opinion didn't consider something that's really essential. So like the example we had was that this little girl has to go lightly administered, once a week, and the clinical rationale said it was once a month. That's a significant difference, because having to go lightly administered, like, incapacitates you for 10 hours, and she's going to be going to the bathroom for 10 hours. It's really, a big deal in terms of what level of care the child might need on a weekly basis as opposed to on a monthly basis. So anyway, I'm just about at time. So I'll just open it up for quick questions before we go. And the questions can be for me or for anyone else here. Sure.
How do you know when the person is in the name of the 60 filing?
Okay, so that's a good question. So the question is about the notice you received, like how do you know, who you're supposed to talk to or whatever. What will happen is when you get a notice, assuming there's actually a notice of hearing rights on there, which it should, and if there's not, you can call me, because that's the kind of stuff that we do are some of these systemic problems with due process and other issues. But you should have a notice of hearing rights. It'll have instructions. It says if you want a hearing, send a request within 10 days to the agency clerk or whatever, and I'll have some information. I think we also have some information and materials about requesting hearings for the different agencies. And so that there will be and that will be just the person you file the request with, but then it'll get assigned to somebody at the agency that you can talk to as well.
If there also in your materials are agency contacts and there's a contact for the general counsel's office, if you're an attorney, you should definitely not be contacting the staff people. You should be contacting the general counsel's office. And you don't necessarily, if you've got something and there's just a blatant error, you've got a document to prove it, you don't necessarily have to run and file a hearing, although you do want to file a hearing within the time period that's required in order to receive continued benefits. And the CFR says that that's before the date of any time before the date of the action. But what they usually do is they give you a notice and they give you 10 days from the date of the notice for the date of the action. So it's usually by the time you get the notice, you don't have a lot of time. But there have been times when I've been able to get things fixed, just calling, saying, look, I don't want to have to file a hearing request here, spend time and money for my client, but this is a pretty easy problem to fix, and you can get it fixed. I can't count the number of times that
fixing things and without having to go to a hearing has done perfectly fine. And I don't have to, I'm not even compromising. I'm not saying, okay, we'll give up 10 hours of nursing over the week. And no, I mean, if you can show you need it and the agency and give them the proof. And if you look at your materials, this case study, I put together like a detailed memo that looks very much like the case study and send it to the attorney on the other side. I don't hold my cards in my hand. I say, this is what we got. Do you want to go to hearing on this? If you do, fine, I'm ready. But why would you? And most of the time, people don't, oddly, people don't join the agency thinking, great, I can keep people from having services. I'm excited about that. All right, well,